number of options you have, even within the regime of penal confinement, and you're thrown into a cell where you're confined for 23 hours, deprived of most of your property, deprived of most of the standard activities and privileges of prison life, often more significantly restricted in your communication both with other prisoners and with the outside world than other prisoners. Well, is that a mental or emotional injury? Well, so far the case law seems to be suggesting that it is. No one has grappled with this question, even at the glib level at which I am presently addressing it. They're simply not framing the question yet, so we don't know how that is going to come out. Third question is, what is an action for mental or emotional injury? You'd think of an action as a lawsuit. You file a lawsuit, you win, you may win part of it, you may win all of it, but everything that you put in the complaint is an action. You can break it down a little bit by the kind of legal claims that appear, because sometimes several different kinds of wrongs will be joined in a single case. But what the courts have done is they've broken it down even further, and they have, in some levels, taken back the notion that mental or emotional injury is such things as stress, fear, and depression. Courts will say that this claim is not a claim for mental or emotional injury, but then they will say, but you can't recover compensatory damages because that would be for mental or emotional injury. You can go forward for nominal damages or punitive damages, however. This is an outcome that I really cannot rationalize. You will find it in the case law. All I can say about this is that at present, for constitutional injuries that do not involve some kind of physical harm, the status of prisoners' ability to recover is very much in question, and many of the courts have not said anything coherent that defines the limit of the incursion the statute has made on the powers of the judiciary. And I will leave you as an example, a case from the Western District of New York decided a few months ago, which facts are as follows. The plaintiff, who was housed in one of New York's women's prisons, was feeling rather agitated, and she asked for some mental health care. The mental health professional, using the term loosely, ordered that she be placed in mental health observation. She was placed instead in a special housing unit, which is the place they put people for punitive segregation. Subjected to a video strip search, she was left in a translucent, half-open paper gown. She had a period. She was given a sanitary napkin, but nothing to hold it in place with. So, she and her paper gown quickly became soiled and bloody. It was not permitted a change of gown or personal hygiene items. Was not allowed to take a shower. The cell was filthy. It was, I think, March or April in western New York, and she was not given any blankets or sheets in addition to her paper gown. And male staff assigned to the unit helpfully observed her every 15 minutes. Even more helpfully, there were some male construction workers in the area for some reason, and they helped out with the observations, apparently. By the way, she received no mental health treatment. Now, the judge in that case came up with a number of extremely ingenious arguments for saying this claim is not barred by the mental or emotional injury provision, that in fact some of what's described here is physical injury. Well, that case will be hitting the Second Circuit before too long, I suspect, and if I were you, I would not make a bet one way or another on the outcome of it, and if it were in other circuits, I would give you good odds that the plaintiff would lose. So stay tuned and we'll see. I would like to move on now to the prospective relief provisions of the PLRA. By prospective relief, I mean court orders, injunctions, orders that tell prison officials, do this, do that, don't do this, don't do that. This is one of the areas that has generated some of the largest amounts of litigation under the PLRA. And here Congress, rather than concentrating an enormous amount of bad drafting in a single sentence, actually went to considerable lengths to try to get it right by the standards of what they were trying to do, and they went on for quite some time. And so will I, although I guess I'd better move fast, or I will cut into the other speakers' time. Anyway, what the PLRA prospective relief provisions do first is set a standard for the grant of injunctive relief in prison cases. They say that no relief can be granted unless it's narrowly drawn, extends no further than necessary to correct the violation of the federal right, and is the least intrusive means to correct the violation. In addition, the court's supposed to give substantial weight to any adverse impact on public safety or the operation of a criminal justice system, and not order local or state officials to violate local or state law unless it's necessary to remedy the constitutional violation. Well, there's a certain rhetorical force to this, but it really doesn't change the law very much. That's the way that courts of equity have always been expected to exercise their powers, with restraint and with concern for the external effects that their actions may have. However, there are a couple of corollaries here which are of enormous significance. One is that this standard applies not only to cases that are litigated at trial and the court decides it's a constitutional violation, but also to cases that the parties decided to settle. In any other kind of case, the parties can settle for pretty much anything they want to that isn't affirmatively illegal and doesn't in some fashion go outside the scope of the litigation as it's framed by the pleadings. But now the relief has to meet these standards, and since the standards are keyed to a violation of federal law, such a violation has to be admitted or found by the court. And the whole object of settling cases many times is to, from the defendant's standpoint, is to avoid having such a finding made. The other extremely important consequence of the PLRA is the judgment termination provision, which essentially says that court orders by operation of this legislation may be ended in a manner that was never contemplated when they were entered. In fact, the thought was not even in effect when they were entered. If the court did not make the findings that the statute prescribes about the intrusiveness, the necessity, the narrowness of the remedy, then a court order can be terminated on motion of the defendants. All they have to do is file a motion, and the burden is then placed on the plaintiffs to come forward with evidence that there is a current and ongoing constitutional violation. Now, there are a number of corollaries of this. But I think the practical consequences is easily described, and that is that the legal protections obtained through years of labor on behalf of prisoners in many jurisdictions have simply been swept away under this statute. And one of the reasons for that is that, as I imagine is obvious, there's sort of a paradox at the heart of it. If the Constitution is violated and you correct that violation by an injunction, then there's no violation, so you can't prove a current and ongoing violation, so presto, the injunction is gone, even if the existence of the injunction is the only reason that the violation ceased to exist. And Congress's answer to the paradoxical character of this is, hey, file another lawsuit. You know, it's easy. Anybody can file a lawsuit. Of course, those of us who have actually engaged in prison conditions litigation could give them an earful, but they don't want to hear it, so there's no reason to. Actually, I think some of us did give them an earful, and they made it clear they didn't want to hear it. In addition, the mere filing of one of these motions triggers an automatic stay of the court order, 30 days or 90 days if you persuade the court that an extension is warranted after the filing of the motion. This is a really unprecedented provision in American jurisprudence, I think. It essentially puts the continued vitality of a judicial act in the hands of one party to the litigation. Nonetheless, the Supreme Court has upheld that provision of the PLRA, and I'm going to come back to some of the separation of powers issues that are obviously presented by that. A couple more aspects of the prospective relief provisions I will mention before I do that. The PLRA has restricted the life of preliminary injunctions in prison litigation to 90 days unless the injunction is made final. The litigation is completely concluded within 90 days, and the question of whether on a new showing of the need for a preliminary injunction you can get it renewed has not really been asked, much less answered. And second, the statute places restrictions on prisoner release orders, so-called, that is, any order that limits prisoner jail population, stating that such an order can only be entered if less intrusive relief has been tried and failed after the defendants had a reasonable time to comply, only after convening a 3-judge court, that is, 2 district judges and an appellate judge, which is one of the more time-consuming and bureaucratic procedures ever invented in the federal judiciary. The court must find by clear and convincing evidence that only a prisoner release order or crowding relief will solve the constitutional problem, and that crowding is the primary cause of the constitutional problem. And it gives state and local officials standing and the right to intervene to oppose any such order. Interestingly, it doesn't give anyone standing to intervene to support such an order. Now, these provisions, as I've said, pose some fairly substantial separation of powers problems. In fact, I think it's more accurate to say that they and the decisions that have upheld them have knocked a big hole in what I think some of us like to think were the walls of separation between judiciary and the other branches of government. And the most serious of these separation of powers issues involves the principle that the final judgment of an Article III court is immune from legislative revision. What I've been describing is obviously a process in which the legislature has acted in a way that permits injunctions that were entered in some cases many years before the statute was passed simply to be swept away. What the courts have said in responses to challenges to the statute are that an injunction is not final in the same way that a money judgment is final, because an injunction can be modified. Of course, it can be modified only by the court. And in the case of money judgments, the Supreme Court had previously said that the fact that the courts have the power to modify a judgment doesn't mean that the legislature does, but somehow that idea sort of fell out of the discussion when the Prison Litigation Reform Act came to the circuits and to the Supreme Court. Second, the courts have said that the prospective effect of an injunction can be changed, but the judgment itself still remains intact. This is a sort of rationalization of what I think is a substantial separation of powers violation that tries to pretend that it doesn't exist. And it reminds me of the old joke about legal reasoning being the art of thinking about something that's inextricably intertwined with something else without thinking about the something else. Well, here you have it, big as life. And finally, the courts have said that in any case, injunctions can be modified based on changes in the underlying law. And that is, in fact, a very familiar proposition from statutory cases. If there's an injunction enforcing a statute and Congress repeals the statute, there's really nothing there left for the injunction to enforce, so why are we enforcing it? And courts have generally responded in those situations by terminating injunctions or by modifying them if the statute was merely amended. But constitutional cases have always been thought to be immune from that doctrine because, after all, Congress can't change the Constitution. Well, what the courts have said is that the underlying law here is not the Constitution. The underlying law is the power of federal courts to grant injunctions, which is subject to legislative modifications. In short, a judgment can now be changed by the legislature if the legislature changes the law of judgments. And I would suggest that that is as tautological intellectually as it is rhetorically. And the effect of it is to erase the distinction between statutory and constitutional cases to a large extent for purposes of the limits on Congress's ability to alter the effect and the immunity from legislative intervention of injunctions. And these propositions have all now been asserted by the United States Supreme Court in a case called Miller versus French, which did not directly involve the provision for termination of judgments. It involved the provision providing for the automatic stay while a motion for termination is pending. But nonetheless, the Supreme Court invoked the same ideas that have been used in the federal appeals courts to uphold the provision for the termination of judgments. And the significance of this in separation of powers terms, I think, is best appreciated when you consider these decisions in the statute in the context of the Supreme Court's prior statements about separation of powers, notably Robertson versus the Seattle Audubon Society, which might better be characterized as spotted owls versus the logging industry. Litigation was pending, as you know, for a long time in that controversy, and finally Congress came up with a legislative solution, and the statute they passed said, in substance, we're passing this statute, and compliance with the provisions of the statute that we're passing shall be deemed to constitute compliance with the provisions of the statute that are relied on in the cases of, and then it proceeded to list them by name and docket number. And the Supreme Court said unanimously that that kind of tailoring of legislation to alter the outcome of a named piece of litigation does not violate the separation of powers, because, after all, Congress could have framed the legislation differently, and they did, and ultimately, in effect, amend the substantive law, and they had the power to amend the substantive law. So put these things together, that in areas where Congress has the substantive power to legislate, it can legislate in a way that is targeted and tailored to particular pieces of litigation, and in constitutional cases, it has what seems to be an equivalent power to legislate with respect to the remedial powers of the court, and that seems to suggest that in a constitutional case, if a federal court does something that Congress doesn't like, that Congress can point its finger at that case and cannot reverse the finding that the Constitution was violated, but it can say, for example, paragraph 44 of the injunction we don't really like, and it will terminate as of 3 days from now, or the entire judgment will have a life of only 1 year, or the particular kind of remedy that appears in this judgment can only be utilized after you've tried 6 other remedies and have shown that they didn't work. And of course, this can also apparently be done not simply tailored to a particular case, but to categories of cases. Well, I'm setting out a pretty radical proposition here, and I may be wrong. I'd like to be wrong, but as the Congress and the appeals courts and the Supreme Court have left the law, there is, to me, no identifiable stopping place in limiting the incursion of the legislature on the powers of the federal courts in these cases, other than the bare proposition that Congress cannot overturn a finding of constitutional violation. And until and unless the courts come up with some conceptual tools to replace the ones that they have essentially thrown away to defend judicial autonomy against legislative incursion, I think that our constitutional rights, not just of prisoners, but of all litigants, are much less secure today than they were before the passage of the PLRA, and that there may be many reasons for persons other than prisoners to regret the passage of the statute. Thank you.
ADEPA and IRA passed a lot of court stripping provisions in the immigration context. I don't want to talk about all of them. You would need a lot of immigration background, and frankly, a lot of it is pretty tedious and relatively uninteresting. What I want to do is focus on one set of provisions. Those are the provisions that affect the ability of immigrants who have committed crimes to get to court. Those are the most draconian provisions. Those are the provisions that went into effect first. They've been the most heavily litigated, and they are also going before the Supreme Court for argument in a couple of weeks on April 24th in the St. Cyr case and the Calcano-Martinez case, two companion cases out of the Second Circuit. I want to touch on three things. I want to give you a sense of how draconian the court stripping provisions are. I want to give you a little bit of a sense of the litigation, and then give you a little bit of a sense of how we've gone about trying to litigate them. That is sort of the strategy behind litigating them, and not spend too much time on some of the substantive arguments made by us and the government, but rather give you a sense of what we have viewed as the challenges in trying to litigate these provisions, both the challenge in litigating any court stripping provisions and then doing so in the immigration context, where litigation in general has been difficult, needless to say, over the years. Let me start by giving you a sense of how draconian the provisions are. First of all, they take away judicial review, not just for immigrants who are here, who are undocumented, who are sort of colloquially here illegally, but they take away judicial review for lawful permanent residents. And for those of you who don't know what a lawful permanent resident, that is sort of in street speak, that's a green card holder. It's the next step before citizenship. They are eligible to become citizens. Most of the people in this litigation could have become citizens, did not do so for any one of a number of reasons. They are now facing deportation because they didn't become citizens, and now they are facing, as of 1996, these court stripping provisions that are stopping them from getting into court. And it just doesn't affect lawful permanent residents. It affects people who have been here for years, decades, perhaps their whole life. There is no time limit on it. So the provisions will apply if you were here as a child, which many of our litigants have been here. They've been here since they're 2, 3, 4. So they've been here legally all their lives. They may be 40 years old, 50 years old, 60 years old now. They've been here for decades. And they also have their own families here. And in a good many of the cases, their spouses are U.S. citizens and their children are U.S. citizens. And they, for whatever reason, did not naturalize, so they are not citizens. So they are faced with these court stripping provisions, but their entire families are U.S. citizens, and they have basically known no other life other than the United States. The other factor that's involved is it doesn't matter when the crime was committed. The court stripping provision will kick in even if the crime was committed decades ago. So these crimes may have been committed when the person was 18 years old, and it doesn't matter. They're here now 20 years, 30 years, and the court stripping provision will still apply to them because there's no statute of limitations for the provision on when the crime was committed. And the final thing is that despite the government's characterization of the provision, it applies, and the courts have held that it applies to virtually any crime. It can be even the most minor misdemeanor with no jail time served. So what we have now are cases in which a person has been here since they're 2 or 3 years old. They've been here lawfully all that time. Their families are U.S. citizens. The crime was committed decades ago. It may have been a misdemeanor under state or federal law for which they served no jail time, but yet the government is now seeking to apply these court stripping provisions. So they are facing deportation. They think there is something wrong with their deportation order, but they cannot get into court to challenge it. And so what they are being left with then, under the government's view of the law, is the only review they get is by an administrative board. And that administrative board is sort of a double-layer review. It's before an immigration judge and before a board of immigration appeals. But both of those entities are part of the Justice Department. So what we're now looking at is a situation where the Justice Department decides we want to deport someone. They go and bring deportation charges. They bring you before an immigration judge and before the Board of Immigration Appeals. The Board of Immigration Appeals ultimately finds that you're deportable. Well, that's the only review you've gotten. But they're part of the Justice Department, the very entity that chose to prosecute your deportation case. And so the government has walked into court and said, well, the court stripping provisions really aren't that bad. You're getting this administrative review. But of course, the administrative review is lodged in the Justice Department. And even worse, if you actually are able to win before one of these administrative boards, the Attorney General himself can step in, which he or she does, and says, I'm going to overrule that decision. And the Attorney General, of course, is the person directly responsible to the public and Congress for enforcing the immigration laws, is under enormous political pressure, particularly now, to enforce the immigration laws, yet that's the only neutral, so-called neutral review you would get, is before an administrative board lodged in the Justice Department, subject to review only by the Attorney General, if the government prevails on its interpretation of the court stripping provisions and the courts uphold that interpretation. So what we're really talking about is a fairly draconian provision, and as far as we can tell, it's unprecedented in the history of the country. What we have are people facing a loss of liberty, deportation. You know, the Supreme Court has said over and over that deportation involves an individual's liberty. So we have an individual facing a loss of liberty, yet the only review they can get is by an administrative board and the Attorney General, the very entities bringing the prosecution, the very entities under that type of political pressure to enforce the immigration laws. We're not aware of any time in the peacetime history of this country in which someone facing a loss of liberty could not have the legal validity of the deprivation of liberty, the order ordering them deported, or in any context, someone facing a loss of liberty who could not get before a court, and that you would lose your liberty based solely on an administrative board who was lodged in the very department that was seeking to take away your liberty. So it's draconian and it's historically unprecedented. Let me give you a sense of sort of how the litigation has unfolded in just a very brief sense. And the litigation has basically taken one form so far. And I want to talk more about the lower court litigation. In the Supreme Court is still going to play out, and we'll all ultimately see what happens. So far, the lower courts have not upheld the government's position, thankfully, and have been actually quite taken back by how extreme the government's position has been. And the way it's unfolded, for the most part, has been over a particular type of issue, a retroactivity issue. And what's happened is that our clients have been brought before an administrative board, and they said, we want to deport you because you've committed a criminal offense. And the immigration laws have long been allowed to, you've long been subject to deportation if you committed a crime, even if it's a relatively minor crime. But what's happened for the last 60 years, because the crimes can be so minor that subject you to deportation, you've been allowed to apply for a humanitarian waiver. So the deportation has not been mandatory. And an immigration judge will look at your equities, will see that you have U.S. citizen children, a U.S. citizen spouse, that your crime was committed years and years and years ago, that it was relatively minor, there's been rehabilitation, you're a pillar of your community, and said, well, I am not going to deport you. I'm going to waive your deportation because I know I have the right to do that. Well, what happened was, at the same time the court stripping provisions were passed, another provision was passed that requires the mandatory deportation regardless of someone's life circumstances. But that provision applies only prospectively. Well, the government walked in before the administrative board and said, we want to apply it retroactively. So no matter how long ago your crime was, we're not only going to strip the courts of review, but we're going to have this mandatory deportation, so the administrative board does not have the opportunity to look at any of your equities. Well, we said that the provision requiring mandatory deportation does not apply retroactively. The board disagreed, and the Attorney General upheld that. So we went to court throughout the country, in every circuit in the country, and we said, look, all we want is the administrative board to look at this person's circumstances and decide whether they are someone who should be deported. And the government walked into court and said two things. First, maybe the Attorney General and the board were wrong to apply this retroactively. Maybe this person shouldn't be subject to mandatory deportation, but we don't care. There's a court stripping provision. No court can look at it. Maybe Congress never intended for this draconian provision to apply retroactively. So be it. That's the end of the matter. The Attorney General has the final say on her own enforcement authority. And the second thing the government said is, well, even if the court has jurisdiction to look at it, we think the Attorney General was right on the merits. The ACLU has principally been concerned with the court stripping provisions, and the courts generally said, look, whether this provision applies retroactively or not has to be subject to judicial review. It cannot be left to an administrative board, particularly an administrative board that is part of the Justice Department, so sort of the fox guarding situation. And The government has, though, continually pressed it, and we're now in the Supreme Court, and the litigation has been going on 5 years. You know, this is immigration. We have not fared well before the Supreme Court over the, you know, any time, but particularly over the last 10 years. So no one is really sure what could happen, what will happen. And the lower court's instinct has been saying this is outrageous, and, you know, there's no historical precedent for it. But nonetheless, you know, we're obviously before this court, and, you know, and anything can happen. And what I wanted to, you know, turn to now is just give you a sense of sort of our thinking about litigating this, at least in the lower courts, you know, up to this point, and just sort of some of the struggles we've faced strategically, you know, in our thinking. I don't know whether we've made the right strategic choices, but I just want to give you a sense of what we've been thinking about over the last 5 years. I mean, as I said, the provisions are draconian, they're unprecedented. It should be enough to be able to bring all that to the attention of the court, because we do have strong legal precedent. I don't want to make it seem as though we're going there and asking for sympathy based on how draconian the provisions are or how historically unprecedented. There is a strong body of law in our support, but nonetheless, it's immigration and it's immigrants who have committed crimes, so it's sort of the double whammy. And not only that, but the litigation has been going on all over the country, so we're not just here in the Second Circuit. We're in the D.C. Circuit, we're in the Fifth Circuit down south, we're in the Fourth Circuit, we're in the 11th Circuit, where there maybe is not as good a body of law on immigration. And so what we decided was that there were possibly 4 ways that we could litigate. There's sort of 4 stories we could tell the court, in addition to obviously giving them our legal arguments, you know, and sort of making a rigorous legal case based on the text of the statute, based on precedent interpreting various constitutional provisions, that we had 4 stories possibly to tell. And the struggle for us was figuring out which of the stories to tell. The first one would be just to tell the facts of the individual who's before the court in that case, the individual immigrant. You know, and you hear all the time, stress the facts, stress the facts. That's what you need to do when you're doing public interest law. And there's no question that that is one way to go. We became concerned, though, that we wouldn't always be able to pick the test case. And in a lot of situations, we might not have an individual who committed a minor crime a long time ago. That the government might be successful in moving a case quicker in a particular circuit in which the immigrant committed the crime 8 years ago rather than 40 years ago. Maybe that particular immigrant doesn't have U.S. citizen family. Maybe that particular immigrant is still unemployed. And that we couldn't control that. So we decided that that was probably not the best way to do what was sort of campaign litigation, where we were litigating the same issue throughout the country with limited resources and would not be able to always get the right case before the court, the most sympathetic case. The second story we thought about telling is, well, we could talk about immigrants generally, how there's a political backlash, how they're politically vulnerable, and talk about that, and talk about how people are talking about immigration with a sort of a blur of statistics, but when you really get down to it, immigrants have been good to this country, that there's a lot of sympathetic stories, and that this is just a situation where people have been picking on immigrants. We decided against that story because we just weren't sure how it was going to play. I mean, what we found is that even in the more sympathetic circuits, that immigrants have not always been viewed as sympathetic, that we probably are at fault for not doing a good enough PR job in the country and making immigrants seem generally as sympathetic as, you know, we believe that they should be, and that it's a situation that immigrants, like citizens, there's always people who commit crimes, there's always people who go astray, but as a general matter, there shouldn't be that hostility toward immigrants as a whole, which you do find. And we were particularly concerned that we did not want to lose too many cases and force a circuit split and end up in the Supreme Court, and that story might float in some parts of the country, but it might not float in other parts, particularly the South, maybe some parts, you know, out west in 10th Circuit. And so we decided against that story. And then we were sort of left with 2 other stories. One was to tell a story generally about the role of courts in this country and about judicial review and how important the role of courts have been in protecting vulnerable groups throughout our country, and that it's a bedrock principle of our country to always have a neutral decision maker where there's someone's liberties at stake at least. A variation on that would be just to tell the story about habeas corpus and talk about the role habeas corpus has played and not made it so general. The problem with both of those stories was that they have a somewhat abstract feel. You know, and generally those of you who have litigated know that you don't want to be in there with too many abstract principles of law, and that you need to sort of bring it home for the judges and the justices. You need to make them want to rule in your favor, because when I say that we had a good body of law, we had good textual arguments, they obviously were not airtight. There was certainly wiggle room. There was certainly arguments the government had to make, and so we needed to move the court in one way or another. We needed to tell a story. But we ultimately felt that those stories were probably better than taking a chance on telling the story about immigrants individually or immigrants collectively and trying to engender some sympathy, even though the laws were so draconian, even though they impacted on long-time lawful permanent residents and their families. We decided to go with a judicial review story with particular focus on the habeas corpus story, and to say, you know, look, that's what habeas corpus has always been for in this country and before that in England, to protect vulnerable groups. And it's not really a situation where the government, of course, would spend pages and pages in their briefs in the lower courts describing the crime, trying to say that the crimes were worse, picking out the people with the worst crimes. We ultimately were successful in telling that story, and I think what the courts ultimately said is, look, we have an institutional role to play here. We've always had an institutional role to play, the federal courts, that is, and we've particularly had a role to play in habeas corpus, and we tried to tell the story of the history of habeas corpus, and that was basically successful in the lower courts. And it's a story, you know, I think until someone says to stop it, we're probably going to stick with, and it's the story we're trying to tell in the Supreme Court in our briefs, and you know, we'll see how sympathetic to that story the Supreme Court is, but it's ultimately the story we went with. You know, it doesn't feel great not to be able to come in and to defend immigrants collectively or your individual clients get held. I mean, obviously, we defended it to the extent we could, but there's a feeling of you want to tell a story about just how sympathetic your clients are, that the government's way overstating the crimes, that these crimes could have been committed by anybody. You know, we're talking about non-violent theft, misdemeanor crimes at 18. Now, obviously, they're not all like that. If they were all like that, we might have tried to tell a story. But we ultimately decided that it was better to tell a story about court stripping provisions, about the history of habeas corpus, about judicial review, and just what role the courts have always played, and to hope that the courts thought that was a story that they needed to listen to, and then that was something that they needed to reaffirm. You know, and so far we've been successful. So we're just hopeful that in the Supreme Court, you know, the story holds up. Thanks.
Thank you so much, all of you. I think we have about, you know, five minutes of questions, and then we should all proceed downstairs to the lovely party that's waiting for us, and we can continue the conversation then. But are there some questions for any of our speakers? Yes, Dan.
This is a question for Professor Lehman. Concerning, I guess, the third prong of society transfer, or Blackstone's will call it, the preservation requirement. Is there a more onerous preservation requirement? What kind of advice do you give to a appellate advocate, state appellate advocate, in trying to preserve the issues in their lien code? Would you suggest that substantive letters are always required now, or a footnote suffice to preserve all the issues for habeas? What are your ideas?
Well, almost nothing suffices. You know, the waiver rules are incredibly stringent now, and you used to be able to get away with referring by reference to a brief that you filed somewhere else, or throwing in an appendix. And the problem is you get into these places where you have page limits, so you can't just put it all in there. But on the other hand, if you don't put it in there, you lose it. And so I think that you really need to go ahead and make a kind of an argument. A footnote is not great, but if it's the only thing you can do, you can do it. You know, my judgment about this is to, you know, sort of like tell the truth, which is to say, look, we think this is a really terrific claim, but we've run out of pages because when we asked you for more pages, you denied it, and we've attached our brief or something else where we've raised this stuff before. We'd like you to consider that. but if but this is the best that we can do. And then you always want to be thinking at each stage of the way what kind of argument you can make at the next stage. And my sort of basic principle about this is, that phrase, you can run but you can't hide, which is we tried. We did everything we could, and it wasn't our fault, it was your fault. And the Supreme Court last year, interestingly, in another case called Williams against Taylor, there were two of them, both out of the Fourth Circuit, held that they want to draw a very sharp line kind of on the basis of who's to blame. And if the prisoner's to blame for not raising the stuff, then the prisoner loses. And that includes the prisoner's lawyer, even if the prisoner's lawyer did something that no prisoner would ever want their lawyer to do. But if the defense side of the thing did it, you lose. But on the other hand, if you tried, and it's this notion of failed to develop, if you tried to do it, then and if you've sort of put the onus on the other this notion of fail to develop. If you try to do it, then and if you've sort of put the onus on the other side, then you're okay. And so that's how I write these briefs, which is to say, here's all the things that I tried to do to get it in, and here's all the proffers that I made, and I'm willing to attach, all of it if you let me, but of course you won't let me, or I've applied and you've denied it. So, I've done the best that I can. But it means a lot of extra work, and it actually also means that you've got to be a pill. And, it's exactly what this was all designed to do, to get away from, which was to streamline and all of that. But you can't streamline. You've got to do the opposite. And, local lawyers tend to want to keep good faith with the local judges. And I was a legal defense fund lawyer. I was always the outside person, so I did this for my local lawyers as a kind of service. But if you're the only lawyer there, you got to just, kind of like buck up and be a pill, even though, that's not a way to make friends and influence people in most instances.
Another question for the professor. You said that the length of time for navigating through the post-conviction process is now averaging 12 years. I found that really amazing. I was wondering if you have, when you looked at the data, if you find any sort of big rush of habeas filings after headstone was passed in order to meet the new statute of limitations. That contributes to a backlog, which was a bit of a delay.
Well,
one other,
yeah,
do you think that our students versus benefits that talk about the properly filed and really come in a favorable way for the defendant? Do you think that's something congressional data?
I don't think so. I think, on the last question, I think Congress, the habeas wars in this country literally started in 1953. Brown against Allen was handed down, and that year there were proposals to take away habeas jurisdiction, and it lasted. There was some legislation in the 60s, but it really lasted, for 40 years, more than 40 years. And I think finally Congress passed it, and from the perspective, all of those proposals got beat. And from the perspective of the other side, they got a home run out of EDPA because they got more than they'd ever thought that they could get, and they'd lost so many times. And so I don't think anyone right now has any stomach for habeas review, particularly because the habeas debate always becomes a capital punishment debate, even though it's a little teeny tiny fingernail of the whole thing. But that's what drives the debate. And right now, everybody's running from the death penalty, not running towards it. And so that dynamic, I think, and there's even some thought that there might be some habeas relief legislation passed sometime down the road. I wouldn't hold my breath about that, but the dynamic has changed enough that people could even think about that and not be, unreasonable. But to go to your first question, we didn't look at cases after 95, and we didn't look at that, but the state court, the Center for State Courts or whatever it is that did that study that I mentioned, they tried to look and see if you could sort of say that it was the blip in the screen caused by those extra filings that was really causing the problem now, so that EDPA, caused that, kind of accidentally because everybody ran into court. And you see in their graphs, there was a big spike in that year. But they tried to control for that, and their conclusion was that even given that spike in the filings, that's not what's causing things to be delayed. It's just the statute. And particularly you see that in capital cases. In capital cases, everybody files for every stage of review there is, except the occasional Gilmore or McVeigh who waives those things, so that there was no spike in capital cases, really, because they were always moving anyway, and if you could always set an execution date to force them along more quickly. So, and the capital cases really drive people's views about this, and it's really there where the state courts and the state litigators and things feel like they didn't get much relief from habeas. They win more of their cases, which they really do like, but they're happening more slowly than even before.
It may be too soon to tell, but in any of the areas you've been discussing, is the change of administration likely to make any difference in the implementation or interpretation of any of these statutes, having Ashcroft instead of Janet Raymond?
Well, I'll say for the death penalty, most of this stuff is state lawyers, and so the problem with Ashcroft is that he was the Attorney General of Missouri and Missouri's a really nasty state when it comes to the death penalty. They really cut back on review and they don't give much relief, and his administration as the Attorney General there was one of the worst, so that his dispositions are about as bad as they get in this. Exactly where that will go, I don't know. I think that Bush is not so interested in making a big deal about the death penalty. So I don't know that he'll want to push it. But the problem with the death penalty is it comes to them. They don't have to go after it, but it will come to them because these cases just kind of percolate through the courts. And when it comes to them, they're not going to give any ground.
Okay. In the immigration context, I think it's too early. There are reports about President Bush being okay on immigration, and I have no reason to believe that he's going to really try and make things a lot worse on immigration. But with respect specifically to the court stripping provisions, I don't know whether we're likely to see anything happen there, because I suspect that when it gets framed as the courts are going to be more involved, then that we may not see anything, even if there are improvements in the substantive areas of immigration. But I think it may be too early to tell at this point.
I noticed when I first year Con Law students to come today, has anybody got the good news?
I do think there's some good news, which is the point I made a minute ago. Since this act was passed, which as a death penalty lawyer, Ursula knows this. I mean, it was the pits. It was like you'd go to these conferences with death penalty lawyers, and it was just horrible everywhere. And all of a sudden, in the last few years, people are starting to worry about these things. And it's not so much that I would look to the courts to be the front line of change. In fact, I think a lot of this is just you want to get as much of this stuff out of the courts as you can and get it into the public sphere and get it debated there. But the courts are starting to respond. The Supreme Court just granted cert to decide whether it's constitutional to execute retarded people. And I just said a minute ago that 1989 they said it was constitutional. And why the Supreme Court would want to get involved with that again is crazy from their standpoint, unless they're reading the newspapers and realizing that it's kind of an embarrassment to them. Now, the real worry is that Justice O'Connor was the 5th vote for that, and she's going to retire over the summer, and we're going to have a reiteration of the decision, 12 years ago. But let's hope for something else.
I think the good news is not in the courts. The good news is in terms of injustice in the United States. I was a speaker at the political resistance at Columbia, in which about 3,000 people showed up against the prison industrial complex. It was a 2-day session. There were 3,000 people there. And I think that we have a role to play. One, we have to expose, as legal people, the injustice, and we have to work against it. It's not always in the courts. It's in public forums. We must at least call for a moratorium of the death penalty in New York State with a view towards having it abolished, and that is a nationwide situation. With regard to your conflict in the how to present your client's case, did you discourage advocates that would bring forth the horror stories and some of the institutional forces in our country that support the rights of immigrants? I'm even thinking of the National Conference of Catholic Bishops,
right,
and other forces like that, and to use advocacy as a way of bringing out or ameliorating or mitigating your conflict.
No, and that's a good point. I neglected to mention that. We absolutely did. We not only did not discourage it, but we encouraged it. And so there were significant amicus briefs filed presenting those stories. And what we just decided to do is make the strategic decision that in the main brief we would try and tell a different story, but get that before the court so that those courts that were interested in seeing it would see that all laid out. And we encourage a broad array of groups.
I think we should now go straight to the end of this letter.
The only thing I would say is I'm interested in
John, yours and Jim's reaction to what Lee said in terms of that strategy. Because, I mean, the idea that the court is likely to be responsible. I mean, I understand that that's an appealing idea from a certain standpoint. I certainly understand in terms of the range of choices that you were articulating. But I'm really interested in what both of you, what your reactions are if you've been in that sort of lawyering team with Lee about this story to the court, because I have to say I have some serious questions in my own mind about it, and I'm just really interested in your reactions as well.
Well, I guess my reaction is that in prisoners' rights, we tend not to think too much about that because what happens in terms of cases going to appellate courts and to the Supreme Court is simply not as predictable as it is in some other areas, to the extent that there's an issue of mapping out a program of litigation. Very often you pretty much have to play the hand that's dealt to you by the actions of pro se litigants or by the accidents of what comes up from the circuits, for example, on the PLRA termination provisions where the initiative is in the hands of the other side. And also many of the things that we have been litigating recently have had to be relatively abstract. For example, the issues with respect to the termination provisions are often, many of them have to be abstract because the legal issues are what they are, and the litigation tends to be class action litigation and is a little more difficult to abstract sort of stories about individuals from that pattern. Nonetheless, to the extent that there is something that you can work with that humanizes the problem, that either in terms of the some sort of the awful injustice inflicted on particular individuals, the reprehensible conduct of prison officials, we would certainly like to do that. But we often don't have the kind of range of choices that you have when you're selecting plaintiffs on a national scale with a coordinated strategy.
I thought it was an incredibly interesting discussion that Lee gave. I mean, really fascinating, and it made me think a lot about the death penalty area, which Lee said it exactly right. It's a campaign. You're thinking about a lot of cases at once. It's a strategy. But he also said that you don't get to pick your cases because you're stuck with the ones that come along. People are going to get deported. There's nothing you can do about it. People are going to get executed. What are you going to do? Say, well, let's let them get executed because they committed really lousy murders. Let's wait for a more sympathetic murder to come along, and then we'll do something. You just can't do that. And what I've become convinced after a lifetime going also back to the Pleistocene of litigating this stuff, not only to help individuals, but with reform agendas in mind, that you can't really do very well with these reform agendas in that context when you have to represent your client and take the cases as they come while at the same time trying to do these campaigns. You do the best you can under the circumstances where you have those clients and you've got to represent them. But I think that's the problem with trying to do reform through that kind of a mechanism, because you're going to have a lot of problems with it. And that's why I think that it's a really bad thing when you are forced to, and sometimes you are, let the courts take over these issues and have the courts be kind of responsible, and let the public, in a sense, think that, well, if fairness is going to be done, the courts are a good body to do it, so it's in the courts and they're all about fairness, so we don't have to think about fairness. And I think that's what happened with the death penalty. People said, we have to decide whether we're for it or against it. But since we're for it, we're going to have it, and the courts are going to decide whether it's fair, and we don't have to think about that. And it wasn't until it started to be a lot of innocent people who kept turning up on death row, even though the courts were supposed to be keeping that from happening, that finally the public said, gee, maybe we have to think about this because the courts aren't. And that's why I think there's been some movement lately. But that's because there was a good way to get it out of the courts. I don't see particularly a good way to get this particular set of issues out of the courts at this point, because there's nowhere else really to go.
Yeah. I think, I don't want to
make it seem as though it was a complete black and white choice, where we were able to have cases with sympathetic clients, needless to say, we pushed their facts before the court. But I think sort of as an overall picture, and I think, Jim's hit on something important. I mean, when you're trying to systematically change a law, but you're also representing individuals, it really is a tricky situation. And what we would often, and we always had local counsel, and often that we made some decisions to be amicus in some circuits, precisely so that we could potentially, to move the law in a particular way without representing the person in all particulars. But it's tricky because we are doing defensive litigation. People are going to get deported, so there's thousands of deportation cases. So the law gets passed, there's thousands of individual deportation cases going through the system. Each one basically was a mundane case before the law was passed, except to that individual immigrant. But all of a sudden, each one presents this enormous court-stripping law, and the government is involved in each one of the cases, and they're moving the cases the way they want to move it. And what we were afraid of is that if we didn't get involved right away in the first ones, then we have precedent in each circuit. And I guess our feeling was that it was the kind of thing dealing with criminal immigrants. If we had lost in the first few circuits, it would have just, the momentum would have carried it, and we would have lost in every circuit. And I doubt the Supreme Court would have looked at it. If there was uniformity in the lower courts against us, I think the Supreme Court might have left it alone. And so we felt it was critical to move quickly and to get in on whatever case the government was moving first in whatever circuit. And so that's sort of the choice we made. But again, I don't want to make it seem like it was a black and white thing, where we were able to push the facts either through an amicus or in a main brief because they were sympathetic. We did so.